thirdly, acknowledging that he has prepared the legal advice on
yes, thank you. I have all of that. I've only just got them, so I haven't read them, but I've got them.
Well, can I just show you how our submissions are organised? And your worship may have a view as to where the time should be best spent. Your worship will see paragraph 2 of my notes. But firstly, I've set out the key findings of that that we would ask your worship to make. Secondly, I deal with dismissal. Thirdly, relief from forfeiture. That was the point at which your worship just the program was the day before yesterday ended. There's nothing substantial in those about penalty because we simply say that the same facts and matters under relief from forfeiture can be applied. Unfair prejudice, there's nothing substantial about that because it's common ground that there was prejudice, the only issue is unfairness. And if you've won on the dismissal or on the forfeiture being one of the forfeit, that all goes forward as well for those values. There's a brief section on the other employment issues, mainly the medical expenses and the management fee. That's not very relevant at all. There's a section on the name trademark dispute. And then there's a final section at the end where we make some observations on the purpose, witnesses, and their credibility. Shall I start with the facts, or would your lordship wish that I skip over that and move straight to the dismissal section? Shall I start with the factual section, or would your lordship?
We'll start with the fact. We'll take your own court.
Well, we say that Mr. Rella is a talented individual. He has an ability to win clients' loyalty and affection. And he, along with you, I don't deny that, presented to Mr. Chadwick a very substantial potential asset to the project that he wanted to embark upon. Now, in evidence, Mr. Chadwick did seek to downplay Mr. Rella's importance. And one can understand why he would want to do that. And I'm not suggesting that he was being deliberately untruthful on that aspect of his evidence, because often with hindsight, we can reconstruct events on a slightly different way. But there are some, we say, very reliable guiding pieces of evidence that mean that the lordship can find with confidence that Mr. Rella was a very important, the most important part of the picture. Firstly, Mr. Rougery's evidence, completely unprompted in cross-examination, not in his written statement, which was his office response. He had the magic touch. Mr. Turtle's evidence, again, we didn't know about this, I didn't know this at any rate, but he told the court that Biche had become known as Biche Roberto, which speaks for itself. Mr. Chadwick, even Mr. Chadwick's evidence, albeit reluctantly, he did accept that Mr. Rella was a talented individual, day 2, page 150, and he did accept that he had celebrity value, in quotes, when I referred him to the article that is B2246. And I also asked the lordship to take into account Mr. Rella's unchallenged evidence as to his contribution and importance to the project, which appears in paragraph 6, 26 to 13, 54, 118, and 175 of his full statement. Now, I am not saying that Mr. Chadwick is not also an enormously impressive individual. He is obviously highly intelligent, creative, a man who is able to grasp considerable detail. I also
Mr. Downs, I don't want me to look at transcripts. Well, I don't at the moment have transcripts in hard copy. I'm not complaining about that, it just is that I haven't got them. And I don't have transcripts in an electronic form at the moment, which I would like.
Yes.
If you want me to look at transcripts, I need to understand how I'm going to do that.
Well, your lordship,
otherwise, don't assume that I'm going to be able to follow you in a transcript at the moment.
No. More important quotes appear in the document.
Yeah.
Your lordship, we must have hard copies, obviously, and electronic copies, and we will see to that. But we'll be here all day waiting for report for transcript. So this is a sort of this is how we have to put it together. Your
But I would find it helpful if I could be provided with electronic versions. That's what is the most useful to me.
It must have been completely wrong. Obviously, your Lordship, I hope your Lordship will accept that considerable effort has gone into this document, but in time available, there may be matters that your Lordship says, well, how do you know about this? Your Lordship can raise these now, or if your Lordship wishes to in writing afterwards, and we'll obviously assist your Lordship with any further assistance your Lordship. Sorry, your Lordship wants. Well, so, turning Mr. Chadwick, I accept that he is obviously an enormously impressive individual, highly intelligent, creative, and a man who is able to bear command of the city do so. I also accept that he is generous, provided that one does not cross him, and he is very, very true. There is, however, we say, a different and slightly more sinister side of his personality when he sees somebody as a threat. We say he can become aggressive and bad-tempered, and that was obvious from his living in the court. The key, my lord, to the new venture was an ownership statement for the through, and it was known to Mr. Chadwick that this was critical. The terms for the venture were recorded in 234 documents in May and July 2010. But at the time, they were important as they set out the expectations for the parties in financial terms and equity stakes, and that was, it must be remembered, the only comfort that Mr. RELLA, Mr. Rivera, and Mr. Turtle had before they resigned their positions at the Chadwick. It also, I should point out, provided Mr. Chadwick with the only protection he had for a very considerable sum of money he had to lend to them. Mr. RELLA agreed to allow his name to be used by the restaurant, thus ensuring the business gained an initial advantage. But only for long as he was involved, and that is clear from both the May and July documents. There was talk of other restaurants and a far more ambitious vision, but this was never fully worked through. But what was never proved, we say, never proved, was that Mr. Chadwick himself personally would have any rights in the name of ROBERTO'S. Although Mr. Chadwick knew that ownership was critical, his intention was that any stake in the business would only be transferred over 5 years, and after he'd been repaid the totality of his initial stake, that is to say, both his loan and also the share capital. He told the court that the first draft of the shareholders' agreement gave an equity stake only after 5 years, and that was the explanation for clause 3.2. But this was not going to satisfy the other three parties, so Mr. Chadwick sought to achieve the same end by means of some ingenious drafting, including clauses which would effectively give the same practical result and indeed somewhat better. Thus, for example, clause 3.7 guaranteed Mr. Chadwick's right to take back the shares. He said that was the meaning of a terminating agreement if his shares and loan were not repaid. But the shares could never be repaid because that would offend the articles which did not categorise them as redeemable shares, and the IoT company's rules of Article 35 and 47, which provide that classes of shares must be equal and the shares cannot be redeemed except for accordance with the articles. So at the end of 5 years, unless some major change occurred in the Constitution, which would effectively have to have been some sort of scheme of arrangement, because to achieve what Mr. Chadwick needed, in fact, I think into 3 classes of shares, he needed his initial redeemable voting shares, he needed obviously the shares of the partners, and then on my end, he needed a residual class of shares with a very low nominal value, which would carry equal voting rights to the partner shares, but which would accrue to him as and when the first class of shares was repaid. It was actually quite a complicated structure he wanted to achieve. So at the end of 5 years, he was absolutely guaranteed his sole discretion that he could just bring the whole thing to the end and get back the shares. I'm not saying that's what was in his mind and intention, but he did leave himself that opportunity if he thought it necessary. A formal document was needed, and Mr. Chadwick provided the draft obviously in August 2011. He was concerned about the rights of the money, and he did seek to avoid the issue deliberately by reassuring Mr. RELLA that this could be dealt with later in a separate agreement. It also explains the slightly vague wording in clause 2.2. However, and that Roberto's claim, Mr. Rella's claim, for his name would become increasingly difficult. Well, it's clear, it was common ground that everything went very well to start with, but of course there was the problem with Mr. Rella's chronic neck condition that seemed to be getting worse. Mr. Chadwick immediately became involved, again, focusing on the detail. He found the doctor, flew him in from the States, even to the extent that he was involved in the rehabilitation afterwards, emailing the doctor as to some novel treatment was available in the States, calling on him for favour email. Now, I do accept this was all motivated by genuine generosity and care for Mr. Rella, and I do accept, as I read from Mr. Chadwick, is naturally a very generous man. But it's also true, and it doesn't diminish that in any way, to point out that his actions must also have been motivated by a desire to protect it says evidence that should be investment. And thus further evidence of Mr. Rella's perceived value for business at the stone. Now, while from an early stage, alcohol became a problem, and it's certainly the case that this was apparently like August 2012, it became a problem because incidents were attributed to the availability of alcohol to members of staff. Mr. Chadwick was concerned that an alcohol-related incident could lead to the loss of the licence, and an alcohol policy was introduced in early September. It provided an exception for the end-of-shift drink that historically certain staff had been allowed. And Mr. Chadwick was content to leave Mr. Rella with considerable autonomy and discretion in the way that he administered the policy. On the 28th of November, there was a further incident, and the policy was revised and became more strict. The end-of-duty policy drink was stopped, and the team reminded staff that there was to be no more drinking on duty. It seems, however, and there is no evidence, that the December policy was largely disregarded. And I do accept that this is something that Mr. Rella and the other senior management must take responsibility for. However, I do point out that there are mitigating circumstances. Firstly, Mr. Rella's unchallenged evidence, and I give the Lordship reference there, was that he was doing this to entertain VIPs for the benefit of business. And that did match with what Mr. Chadwick was saying in his evidence. It wasn't suggested to him that that was untruthful. A man with 50 years has told the Lordship in the business. Secondly, it wasn't just Mr. Rella, it was all of the parts. I mean, it's all very well saying Mr. Rella is a senior employee, but all of the other three parts on the clear evidence were given. The only one who denied this is Mr. Rella, who denied it on the highly improbable basis that the entries in the PAOLO were false. Well, that cannot be right. The PAOLO was disclosed as by the claimants without any suggestion it wasn't reliable. This is turbulent evidence of bullshit is probably accurate. If there was any suggestion of those evidence that those entries were unreliable or untrue, the claimants would have sought to produce evidence to explain that. So it was Mr. Rella and the other two partners, Mr. Nicogo and Mr. Turner, who were guilty of misuse of control. And the only other mitigating circumstance is that their obligations of alcohol consumption and the evidence that the Lordship saw on the CCTV footage, which nobody seriously suggested was not typical, otherwise your Lordship would show other examples, was evidence of somebody sitting down on that clip, not even with a glass in it, but there are other clips with a glass in it, but calmly, not under incentive, not in incentive, inebriated or drunk, having a chat with somebody in the premises after hours. Well, I accept that if it wasn't for those mitigating circumstances, your Lordship could characterise this as a serious breach of the policy, not serious cause, but a serious breach of the policy. As it is, I accept that it's a material breach of the policy, if your Lordship takes account of the mitigating circumstances. Now, Mr. Chadwick the trigger for Mr. Chadwick's reaction was his discovery of Mr. Rella's disregard for the policy from about early January. He was incandescent, and his attitude to Mr. Rella changed. In his own words, my relationship and my trust in Mr. Rella turned 180 degrees. Well, I can say that literally he flipped. He became obsessed with the issue and started gathering bring evidence against Mr. Rella on wholly unrelated matters, including a supposed issue of absenteeism. Mr. Rella was suspended on the 26th of January, but Mr. Chadwick needed to keep his other partners on board, and so he secured their agreement for this course by assuring them that this was for rehabilitation. His agenda was not rehabilitation. His agenda was to conduct an investigation so that he could secure the termination of Mr. Rella's employment and get his shares back. Mr. Rella was not given a copy of the suspension letter. He wasn't challenged on his evidence in that regard. And I asked your worship to accept his evidence and decide it under pressure. It was very foolish of him indeed to sign that letter without reading it on his evidence at all. And your lordship may think that that was unbelievable. But my lord, what is believable in the situation that he was faced with, and what is believable in a courtroom years later are two different things. And from that side, I suggest that human experience, somebody who feels that they have very little choice may very well just do everything with the last application in the hope that they will get through the problem. If he didn't read the letter, including the words above the signature, he cannot be castigated as dishonest. He can only be castigated as negligent. Mr. Chadwick secured the services of Dr. Shafi and insisted that Mr. Rella take extensive and highly invasive medical tests. Mr. Rella cooperated in full, and when the test gave the all clear, he pleaded with Mr. Chadwick for his return to work. Mr. Chadwick did not give the matter any serious consideration. This was because his mind had been made up a long while ago. He pressed on long after the investigation was completed on his own evidence in early February and sought more damning evidence from Dr. Shafi's first to support his decision. Unfortunately, this evidence was not forthcoming, and all the medical evidence supported Mr. Rella's expectation that he could return to work. By early April, Mr. Chadwick decided the position was not going to get better with regards to medical evidence, and he decided to effect the termination of the appointment. He untruthfully told Mr. Turner that Mr. Rella was not following his doctor's instructions, and in order to repeat him further, that should be in order to repeat Mr. Rivera agreed to fund the purchase of his house. Now, in our line of law, we rely on the following four grounds to challenge the lawfulness of this termination. The first ground is inadequacies of the written notice. The second ground is the failure to make out the grounds in clause 8b of the employment contract. The third ground is the failure to act as a reasonable employer, and the fourth is the failure to satisfy the more strict requirements of clause 3.9 of the Sheffield Agreement. Well, in relation to the written notice, paragraph 6, there are four sub-grounds that we rely upon. Firstly, the failure of the written notice to specify the points of the court in reasonable detail. Secondly, that the written notice did not in fact state the true grounds for dismissal. Thirdly, the written notice will not serve in good faith. And fourthly, there's a failure to rely on the grounds that are now relied upon, ABB, ABC, and ABBF. So turning then to the reasonable details, well, it's a mandatory requirement of clause 8b that the employee is given notice with reasonable detail. I just showed the lordship that in the employment contract, in the court bundle at page 52, termination for cause. Underneath that, the employment term and executives appointed hereunder may be terminated, one, by the company for the cause as defined below, and these are the important words, by written notice specifying the grounds for cause in reasonable detail. And we say that's a mandatory requirement, and if that isn't done, then there is no termination for cause in accordance with ABB or this contract.
When did Mr. Rella first take the point that he hadn't been given a notice which complied with the contract?
Lord, it is in the defence. It's pleaded that the notice was unparticularised.
But I think I'm right in saying he never asked for a more particularised notice.
He didn't, but he's not obliged to. That is, the employer must look after himself in that respect. it's the section in the defence. It's from paragraph 26 onwards. And we would say it's clear that we are attacking this notice. And on the first was at paragraph 26, the termination is concerned by letter of the same date, which cited various unparticularised alleged breaches of public policy by the defendant as grounds for termination. Page 28. And does your have that?
Well, I do, but I haven't yet seen the passage which says the notice was maintained.
Well, the notice said that paragraph 21, the defendant averts that his dismissal for serious cause was a sham, designed and implemented by the second claimant, solely for the purpose of dishonesty, procuring expenditure. Well, all we need to do in the statement case is plead the relevant facts. We have pleaded the relevant facts. What then follows, the consequences and the legal consequences of that are a matter for the lordship.
Yeah, but the position you're making at the moment is that his employment was never terminated.
Well, it probably was terminated. He was repudiated. He was ejected from the premises and probably accepted that. But what I am saying is he wasn't. The employment wasn't terminated in accordance with Clause 8. Very difficult to say that there wasn't a repudiation and he didn't accept it.
Well, where do I find the allegation that there was a repudiation of the contract?
Well, your Lordship doesn't. I'm simply saying your Lordship said presumably his employment was never terminated, and I've said that's not what I'm saying. I don't think we ought to say that it was repudiated. The claimant's case is that it was brought to an end. That's common ground. All that's an issue before your Lordship is whether it was brought to an end in accordance with the agreement. Well, can I just show you? Can I follow it through before? Well, can I just show you what's said in answer to this in paragraph 22 of the reply? As for paragraph 26, it's denied that no warning evidence in support of proper investigation or allegation that was given or undertaken with respect to decisions to terminate defendant employment with first plate and defendants, which is strict proof in such regard. It's further denied that any indication is given to defendant which returns to work on information health and fitness. The claimants assert that the investigations carried out and evidence gathered from staff more than confirm the grounds set out as danger letter and comprise serious cause entitlement for the first claimant lawfully to terminate defendant's employment with effect. There's no point taken on the allegation that the letter was unparticularised. And can I also show you, Lordship, paragraph 38 of the reply? The only case pleaded in relation to the grounds that are to be made is at 38b. This reply contains no particularised case in relation to reliance on sub-clauses that the learned friend sought to and does rely upon at this trial. In opening, he relies on this, I think, C, B, C, F, and A. That is not set out, and no facts are pleaded here. So, for example, I think in re-examination, he sought to rebuild the case or construct the case under HDH as the interference with duties. Well, none of that is pleaded. No particulars of the absenteeism, for example. So if pleading points are to be taken against me, I've got quite a few. We submit that the reasonable detail has two aspects.
That's what I'm looking for at the moment. It's an allegation that the notice failed to specify the grounds in reasonable detail.
It doesn't say that.
It may be necessary, obviously it would be necessary to consider whether there were grounds, but I have not appreciated from the defence that the technical point was being taken that the written notice failed to specify reasonable detail. I just don't find it that way.
It doesn't use those words more. Well, can I just can I just show the Lordship as well in terms of, it's not in the pleadings, but in Mr. Rella's evidence, at paragraph 168 of his false statement. Paragraph 168 of Mr. Rella's false statement. During the meeting, despite the discussion of what I thought we were carried out of the blue, Mr. Chadwick accused me of breaching the ROBERT company policies. He read from the letter and mentioned several breaches. He did not give me any information or details about these breaches. All he said was that I breached the outlaw costing license conditions and said I'd been absent from work without permission. He did not elaborate on anything. Well, we come to court and cannot seriously be said into me that on the fact the defendant is taken by surprise to complain of lack of supervisation at that time. It's true, your Lordship's right, we didn't plead, and therefore, but that's a consequence that follows as a matter of law of construction of property. And the contract, the document is on the ground. There's no factual dispute about what the document says. There's no dispute about what the contract provides in this regard. So, in my submission, that is not an issue of fact, that is an issue of law for your Lordship. And it's perfectly open to me to raise this by way of those arguments. So if I am allowed to raise it by way of my placing of submissions, and if your Lordship's going to rule against me on that, I would want the opportunity to advise on anything, because it would be, it's no conceivable prejudice to the other side. It would be an amendment that would not require any new facts. And it would be that if it's the only point that I need to win, it would be a terrible injustice to relatively define rights on the basis of the fact that the defence doesn't spell out with precision. But my primary position is that it needs to cover the facts, and that's all I need to do. So if your Lordship does allow me to raise this point, either because it's sufficiently clear, or because I have to allow to amend, we suggest that reasonable treatment have two aspects. Firstly, reasonable for the employer, given its own knowledge and resources. Secondly, reasonable for the employee to enable the employee to take advice and understand his or her position. The termination letter satisfied neither, and I dealt with this in cross-examination with Mr. Chadwick and Mr. Mosler, and they both accepted it. What they both said was that the details were given separately. We don't accept that. Mr. Rose evidence challenges that, but even if that were right, that would not be sufficient, because clause 8b requires that the written notice specifies the correct.
Mr. Rella was given a notice which purports to set out the grounds relied upon. That's what the notice seeks to do. My recollection is that he signed that notice. When did he first say to his employer, I don't know why I've been dismissed?
Well, through his solicitors on the 29th of May, can I show your Lordship Bundle D? Bundle D and step 1. headed without prejudice, but it's column, it's in the bundle and nobody has suggested that it's not properly before the Lordship. 29th of May, does your Lordship have the heading employment by the bottom whole column? Employment, we refer to the letter as
Why is this letter headed without prejudice?
I'm told it's an error.
An error?
That's what I'm told.
By ultimately. I mean, they know perfectly well what the without prejudice letter is and what it isn't. That's what's that. Why would it be said to be an error? Somebody typed the words in with their eyes shut or something.
Well, we can embark on an inquiry as to how those words came to be inserted in the market. I would submit it's not going to assist the Lordship at all. The plethora of English case law on why, when without prejudice, is properly and improperly inserted in documents and relied upon would suggest that if it was an error, it's not an uncommon.
And the reason for heading a letter without prejudice is to prevent the recipient from relying on it.
Well, it is.
In court proceeding.
Well, it's in the agreed bundle, so that's
As I said, presumably that was what your clients had in mind.
Well, I'm told it was referred to by the other side as well. Well, if your Lordship wishes to exclude this from evidence, contrary to the common ground and position of the parties, we better do that now, because I shouldn't show your Lordship any more of it.
No, I'm just trying to understand how the point that the notice didn't contain sufficient detail can properly be raised not in the pleadings, which is where it should be, but within a without prejudice letter.
Lord, it was raised, we say the fact that the notice was untouched was raised in the pleadings. The legal consequences of that were not, I agree, spelled out in the pleadings. Your Lordship said, when was it first raised? And I'm simply showing your Lordship.
Well, then you show me the passage where what is said is that the letter, the notice, didn't contain sufficient detail.
Well, the paragraphs that I rely upon are on the first page under the heading employment. And the first of the letters I have is the 3rd of April, reporting to terminate his employment with ROBERTO'S Club. Our client does not accept the validity of the reported termination in violation of DIFC employment law. Your purported termination of our client's employment was without cause on the basis that it was unreasonable in fact in the breach of your duties.
But there's not a hint there that this is in violation of paragraph 8 of the employment contract.
I do accept that. But that's a very, very strict threshold to require a party before justice can be done. If the party, unless you're pleading, makes clear all the legal consequences of the facts that you set out, I'm not going to do justice in the case. I'm not going to find it for you. I'll shut my eyes.
Mr. Downs, I don't think I have said that I'm not going to do justice in the case. And if you're looking for a ground of appeal, you won't find it in a comment of mine that I'm not going to do justice.
Well, I hope you shouldn't think that I wasn't.
Well, that's what you were saying. But I'm seeking to do justice to both sides. And one of the factors that I need to ask myself is whether the grounds were specified in reasonable detail. And one of the things that would be of interest to me is whether your client ever thought they weren't. Because what is reasonable detail is detail sufficient to enable the employee to understand why it's been dismissed. And therefore, if this was a real point, I would expect the employee to be saying to the employer, I don't understand why I've been dismissed. But that's not what this letter says.
Well, can I answer that?
And so I'm just looking for evidence which
explain to Your Lordship why that's an irrelevant factor. The sufficiency of the written notice must be determined as at the date of the written notice. It either is or is not a valid termination letter on that date. The employee's reaction to it and opinion of it would not be admissible factors in determining whether the notice is sufficient. So an employee who is, for example, the next day offered another more attractive job who just doesn't offer, goes off, never asks, but has been in fact served with an invalid notice, is in exactly the same position as an employee served with an identical form of notice in identical circumstances, who the next day sends a letter saying, I need full particulars of this. The employee's reaction and opinion to the notice can't affect the legal notice. That must be determined as at the date. If I'm wrong about that, we will check to see whether that point was raised. It certainly has been, I don't think anybody could say that it's not been complained in the course of this trial that the notice didn't give any details. And I mean, when we come to look at absenteeism, we have been completely dark, as the case may be. It was 5 days, according to some documents. Mr. Rebella challenged that in March. Then Mr. Chadwick, at the outset of his examination, says, well, I'm for 7 days. I couldn't find that anywhere in any of the documents. So we have been complaining in the course of this trial that we were not given sufficient information. One prime position is that whether it's a valid notice is a matter of law. I don't know what Your Lordship wants to do, but Your Lordship, I can skip over this topic and come back to it if Your Lordship would prefer it. Or I can sort of...
Well, Mr. Downs, at the moment I'm inclined to view that whatever I do, I should be told I'm not doing justice to your client. So I'd not just sit quiet and let you go on.
Well, I apologise to Your Lordship sincerely if Your Lordship felt my suggestion. What I was seeking to do was persuade Your Lordship of the right course, and so do not use the expression of the party. What I wasn't suggesting to Your Lordship was going to do anything other than seek to do justice in this case. And neither would I. Well, I'm asked as well, the complaint in relation to particulars, I'm asked as well to show Your Lordship the second statement of RELLA, which is in bundle A in tab 27. Perhaps I can just show Your Lordship that quickly. He says, I cannot stress that at no stage will I provide with any details or evidence whatsoever in support of the allegations set out in the letter. Today, I'm unable to respond to the vague allegations the vague allegations set out as no particulars have been provided. I note also that despite making numerous allegations against me, the second respondent, despite having the opportunity to do so, still failed to provide even a glimpse of the alleged evidence relied upon to dismiss me. Paragraph 5 refers to the absence of any particularised allegation and or evidence. I could and would not acknowledge my guilt. Paragraph 8. I was not and have not been provided any details, let alone any evidence, either orally or in writing, regarding the results of any investigations. The only investigations that were carried out goes on to another topic. It says at paragraph 7, again, I've not seen any evidence or any records confirming the same. Well, the point is this, if one just steps away from the technical aspect to the legal point, we've come to court in this trial, and that evidence and the other matters we suggest made it apparent to the defendant that it was part and parcel of the background, part and parcel of the complaint. Now, it was open to them to put in evidence and make that point and say, no, you're absolutely wrong about this. You were given this document, and this provided you with the reasons or particulars, or whatever they want to to do, and they stayed silent. And the Lordship, we would suggest, is left with the irresistible conclusion that the letter, in fact, is the letter. And we didn't have any details. Well, I was going to suggest trying to get your Lordship's assistance as to what would be reasonable in these circumstances. And we suggest a matter of common sense that reasonable detail involves consideration of two aspects. Firstly, reasonable for the employer, given its own budget and resources. So, for example, an employee can't expect to have details of things that the employer does not himself know at that stage, or that would be impossibly expensive or time-consuming to set out. But also reasonable, there's a balance here, we suggest, but it's also, the details have to be sufficiently reasonable for a hypothetical employee to take some advice and understand their legal position. And of course, each case will turn on its facts, but will we say that here...
Well, I'm not sure why you say a hypothetical employee. What your note says, reasonable for the employee to enable the employee to take advice and understand his legal position.
Oh, yes.
It had seemed to me, at the moment still does seem to me, that if I have to ask whether the detail is reasonable in the context of A to B, one factor that I might regard as important is whether this employee ever said, I don't understand why I'm being dismissed.
Well, if one's going to, if one's right to suggest that the issue is an issue of law and sometimes out of date of the letter itself, it's very difficult to see how anything subsequent can be relevant. I'm trying to think there may be an example of which is called by sound one. I suppose there might be a hard case where the day before the employee is given a list, take absenteeism as an issue, it's a good example. The day before the employee is given a list of dates that he said to be absent, and he's asked for an explanation, and he comes up with the best explanation he can, looks into it, and that's that. And then the employer says, you are dismissed for the absenteeism you referred to yesterday. I could see there, the court might say, well, in the circumstances, that was reasonable detail. I think I would still suggest that if there is no detail on the face of the letter, the employee is entitled to take the point that the letter is on the time. But I can see that there is scope for finding there. But well, that's not this case. Mr. Redline had been suspended throughout this investigation. He had not been, it's not suggested he was given access to any of the findings. He wasn't given an opportunity to respond. It's not been suggested that there was any fair hearing in that regard. And the absenteeism is a terrible example because we still don't know. Still don't know really what the dates are supposed to be. The investigation that we was told took place by Mr. Mossad, the person who carried out the investigation hasn't been called to witness. And none of the facts and matters, I think we should very keen on the opinion point, but none of the facts and matters relied on are set out in the infringement trial. So it doesn't say in answer, you were absent on these days, X, Y, and Z. All that Mr. Rella could do in his evidence is he recalls the chain of emails and absenteeism. He refers to that and deals with that in his evidence. And meets it, as best he can, relying on the company's own records. So we simply say, and it's a matter of law, we say that this letter did not contain reasonable details. It was the only ground. In fact, even my hard case would work. That doesn't work because the terms of the contract explicitly say. I'll just turn it up again. By written notice specifying the reference reports in detail. So, under the terms of the contract, it's not sufficient that they are contained in the second document. They have to be in the notice. Well, this is the employer's draft. It's not our draft. The employer can be expected to look after themselves. It's not unattractive for an employee to insist that the strict terms of the employment contract are adhered to in the course of the dismissal. We say that in truth.
Mr. Downs, I reject the submission that I am not able to do justice in this case because I am very keen on pleading points. The position is that the rules are designed to ensure a fair trial. Pleadings are intended to enable each side to know what points they come to meet. If they don't know which points they come to meet, there's a danger of not having a fair trial. And if I think it's important to have a fair trial, then I stand to be criticised if you think that's wrong. But the suggestion that I'm not going to do justice in this case because I have some obsession with pleading points is one that's rejected. But this is not a pleading point. This is quite a different point. The point here is whether, in asking whether a notice contains reasonable detail as to the grounds, it's relevant to look and see whether the employee thought that he was being told in sufficient detail why he was being dismissed. That is indeed what A and B of your submissions say. Reasonable detail has two aspects. Reasonable for the employer to enable the employee to take advice and understand his legal position. You would expect either that the employee says to the employer, I don't know why I'm being dismissed, or his lawyer says to the employer, I don't know why he's being dismissed. But at the moment, I don't think we've seen either of those things.
As I explained when I made this submission, that is a hypothetical. And the Lordship must adhere, we suggest, to the words of the contract, which say, by written notice, specifying the grounds for reasonable detail. That is a mandatory requirement of this contract. And if your Lordship is not satisfied with that requirement is met, it cannot be a termination under 8B. It might be a termination under some other route, but it's not under 8B. I maintain the opinion of the employee is irrelevant. Let me give your Lordship this example. An illiterate employee and a literate employee are both caught doing something together that is, without question, within 8B. They are equally responsible. They are both dismissed with a letter of termination letter in identical terms. The illiterate employee takes it away and asks somebody else about it. The literate employee says, well, I need more detail. Now, it can't be right that one letter does satisfy it and one does not. The opinion of the employee is a matter that is not material. People differ in their reactions to these situations. Some may be more astute, as Mr. Capriano was when he was given his written notice. He went down clause by clause and said what he agreed with, disagreed with. Mr. Mr. Allen may be a different sort of person, but that your lordship could be assisted by the reaction or opinion of everybody. We expect it to understand. Lordship probably has the point. Well, the second ground on which we attack notice is that it did not set out the true grounds for dismissal. We say that the true grounds for dismissal are apparent from the document, the email, from Mr. Chadwick to Mr. Chadwick, the 22nd of March, which is at B3523. The lordship read it, I think, with some care, and I wasn't going to go to it. What I say is that that demonstrates that the true reason for dismissal was that Mr. Bell was thought to be insufficiently contrite, failed to accept responsibility, apologise, and admit that he was an alcoholic. These matters would not support the ground for dismissal of the and they were not relied upon in notice. Now, they were the true grounds for dismissal of the evidence. But we also say the termination was in bad faith. And in support of that allegation, we rely on a number of factors which I set out at paragraph 12 of the note. And if I can just go through those. Firstly, there was a false description, we say, of events on the 20th of January by Mr. Chadwick, and the email that he sent to Mr. Moster. He said, I could smell alcohol on his breath and he was visibly shaking. And I point out more in the note that his evidence on this was highly unsatisfactory. And I set out the extracts. So 12A1, question. Then you say that Mr. Allen came to the restaurant at 7:11 to 7:15, returned at 11 and had very important 20th of January. Answer, yes. Question, you witnessed that, did you? Answer, I told you. The security guard reported it to me. Question, so you didn't witness any of that? Answer, I told you what the security guard reported to me. Question, are you agreeing that you didn't witness any of that? Answer, I'm answering your question. The security guard reported it to you. I'm taking that as a yes. Then, a little bit later, answer, yes, because I went to the restaurant that night. Question, but you said a few moments ago you didn't witness it. It was the security staff who told you. Answer, if you notice, there are 3 or 4 emails that I sent regarding the absence. I'm not sure which one really relates to the incident, but I did ask the security guard one actual, and I witnessed it. Or 3 or 4 emails I sent to make those references. Voice the question. Next one. Question. Did you yourself witness Mr. Rellen's absence from the restaurant from 7:15 to 11 p.m.? I don't know if I witnessed 7:15 to 11 p.m. I remember being at the restaurant at 1 o'clock and seeing Mr. Roberto. Next thing goes on. Did you witness that when you returned and you could smell alcohol on his breath and this was shaking? That's what I wrote. That's not an answer. That's what you wrote. Is it true? That's what I saw. Is it true? It's true. And then we come to the last section. Sorry, you did observe him departing from the restaurant. I thought earlier you said you didn't observe him departing. You observed him coming back. Okay, coming back, departing. I was there that evening. Which is it? The first time you said you didn't witness anything, you were told by the witness and security. The second time you saw him coming back and not going. Now you say you saw him going and coming back. Which is it? Answer. I told you, I was there in the evening, I spoke to him in the evening. If I remember exactly when you left, it's been a long time. Which of these 3 is it? It's a long time, I don't remember. More I submit, you cannot possibly find, on the basis of that evidence, that the email of the 20th of January was based on an eyewitness account. Follows from that is false.
What am I to understand by the assertion that the termination was in bad faith? There seem to me at the moment to be 2 possibilities. The first is that when terminating the employment, Mr. Chadwick did not in himself think there was ground to terminate it. That might be described as bad faith. The second is that although he did think there was ground to terminate it, his real reason was not the grounds that he gave that isn't the real reason for termination. I was listening and expecting that you would put to Mr. Chadwick either that he didn't really believe that there were grounds for termination, or that his decision to terminate was not based on the grounds he gave, but on some other ground. And if you did, I don't recall you putting those to him. If you did, that would be helpful to see. I said I don't recall it because I was looking out for it and I didn't identify it. But if there is some other basis which is said to substantiate an allegation's bad faith, it would be helpful to know what bad faith means in this context, or rather, more accurately, what you mean by it.
Well, I don't say that Mr. Chadwick did not himself believe that he didn't have the legal right to terminate. I think it's clear from the evidence and the inherent probabilities that he believed, and still believes, that what he did was perfectly lawful and justified.
Well, that may be, it may be that he was mistaken, but that isn't a badge of bad faith.
No, I don't suggest that on the 3rd of April he thought to himself, if I dismiss Mr. RELLA, I don't have a legal leg to stand or legally, but I'm going to do it anyway. I don't suggest that. That's obviously not what happened. By bad faith law, it's more the latter. And what we would suggest, there are very many aspects to acting in good faith or bad faith. But the two tainting factors we suggest here are acting in good faith. You give the employee genuine reasons for dismissal. And I did put in my recollections, but I will reference to Richard. My recollections I did put in when I showed him the email on 22nd March, document 33523. My recollection I did put in that the real reason for the dismissal was the fact that Mr. was insufficiently repentant, and using the word repentant, which I think was a book, the search for that transcript. And my recollection is he denied that. But the other aspect to all of this was the agenda that we said rose at the certain legislation meeting, that he was giving the impression to Mr. RELLA, to Mr. Bravera, and Mr. Turkle that it was all about rehabilitation. But in fact it wasn't. It was about building a case against Mr. RELLA, so that we could dismiss him subsequently. And we say that is bad faith.
Well, taking those 2 points in turn, it seems to me that one could have a situation in which an employer believed and had grounds to believe that there were good reasons for dismissal. But in deciding whether or not to dismiss was influenced by a view as to what the future held. In other words, do I dismiss this person because of what has happened and I don't think it will get any better? Or do I decide not to dismiss it because I do think it will get better and won't happen again? That seems to me to be a decision which an employer is entitled to take, and it's not to be categorized as bad faith. The second point is the hidden agenda point. I'm not dismissing him because I don't want him as an employee. I'm dismissing him because I think that's a way of getting his shares. And that's been a subtext. And I don't recall that ever being put to Mr. Chadwick, but if it was, then I would be interested to see how it was put or what his answer was.
Well, that's fair. May I
Yeah.
look?
In other words, this was all a pretext to get his shares.
Well, I did put to him that at the suspension meeting there were three possible agendas. There was the rehabilitate, there was the investigate, and there was the terminate. And I said to
Well,
him,
you get Mr. Dow, or find it yourself, as to where this actually is, because I was looking out for this question and answer, and I don't recall it. And that's why I would be helped if I could see it.
well, yes, but
I mean, the question is, in effect, Mr. Chadwick this was all a pretext, wasn't it? It wasn't that you didn't want him as an employee, but you could see that that was a way of getting the shares back. I just don't remember that.
Even if I will check, but even if I didn't do that, that doesn't diminish the point, because an employer who acts in for one reason and in fact has a different reason, and particularly where the false reason being given is to organise and keep on board the other two partners. Well, I do say that's bad faith.
Well, if you're going to make that point good, or if that's what you mean by bad faith, then I do need to see the evidence on which you rely. The proposition that Mr. Chadwick's motive was not for the benefit of the business, didn't want to have this employee in the business because it wasn't good for the business, but the motive was that it was a way of getting these shares back. If that is your point, then I do need to see the evidence which supports it.
I'll check that, but I set out here the particulars of that faith, and they're all in the evidence, and they're all put to Mr. Chadwick. And if your lordship concludes that on the basis of this evidence these facts happen, we will say that that's more than enough to conclude that the termination was not conducted in good faith. And so there's the A is the false description of events, creation of party records. B is telling Mr. Rivero, and I said earlier it's the term, I'm so sorry, Mr. Rivero wasn't following the instructions, and cross-examination, Mr. Chadwick accepted what he said he didn't know that he was following Rox's instructions. So Mr. Rivero, his own evidence, has said that's what he was told, that must be a false statement. That's evidence of that faith. Example of that faith. The email with Dr. Shafi, where he says he makes false statements about doesn't acknowledge he has a drinking problem. When he knew that wasn't true, in his own evidence, he said voluntarily that Mr. Redden accepted he had a drinking problem. That's evidence of an example of that faith. Moving the goalposts is acting in bad faith. So saying that he wasn't sufficiently contrite when in fact he acknowledged the problem, accepted responsibility and agreed to attend therapy problem. Disregarding the email of the 7th of March, the Lordship report, the email of the 7th of March was the one that Mr. Brooks said I accept big responsibility, or big part of responsibility. And when I put that to Mr. Chadwick, he said, I just disregarded it because I thought it had been drafted by somebody else. Seeking to poison Dr. Shafi's mind with inflammatory descriptions of Mr. Rella, by the way his eyes were swollen and shaking the entire time he looked very restless and apprehensive. I don't think any of that was put to Mr. Rella across examination. Suggesting to Dr. Shafi that Mr. Rella's mental health was suspect. There's no evidence to support that, and he said he wasn't qualified enough. And my Lord, the way in which he dealt with the investigation, and Mr. Rivera is, we say, bad faith. He did know about the contents of the Bible. His own witness, his own chief financial officer gave evidence that he was told about the contents of the Bible book, and he did nothing about it. And that disparity of treatment between Mr. Rivera and Mr. Rella, we say, is an example of bad faith. Equally, the way he dealt with Chef Luca, he disregarded the evidence in relation to Chef Luca because he concluded that he was drinking because Roberto encouraged him to do so, underlining the quote. But he wasn't even interviewed about this. Nobody was interviewed about this. And that demonstrates bias, demonstrates that he had already made his mind up as to what was going to happen here and was going to achieve it. The frivolous case on absenteeism and the suggestion that Mr. Rella was not working his full quota of hours, when in truth, neither of the witnesses that were brought to court to support that part of the case could support it. And we do ask the Lordship to draw adverse inferences from the failure to call Dr. Chadwick, so that we could at least cross-examine and investigate the extent to which Mr. Chadwick was actively seeking to affect his opinions. And there's that old, the Lordship remember this odd point about the fatty liver, that the ultrasound report which we had in the London.
The only inference I draw from the fact that a witness is not called, it's either that the witness was not available, or that neither party thought that the witness would say anything helpful to their case. Perfectly, after all, Dr. Chadwick was your client's doctor. There's no reason why either side could not have called Dr. Chadwick if they thought he was going to assist their case. I'm not minded to draw an inference that he would have destroyed somebody's case. It's not how it works. You could have called Dr. Chadwick if you wanted to.
Well, it's not how it works. The Lordship, it is inherently improper that somebody would call a witness or compel a witness whose sympathies would naturally lie with the other side. The problem is that they are deprived of the forensic advantage of cross-examination.
No, I have no reason at all to think Dr. Chadwick, if called, would not have given perfectly straightforward and honest evidence.
No, the problem
Either side could have called him. It is not a ground of criticism that the other side doesn't call somebody to let you cross-examine. They don't. They call a witness if they think that witness will assist them. They didn't call Dr. Chadwick, and therefore I would like to take the view that there's nothing Dr. Chadwick would say that they thought would assist them. Equally, you didn't call Dr. Chadwick, so presumably there's nothing that you thought Dr. Chadwick would say that you would assist you. I'm just not going to be persuaded that it's a matter of criticism that some party doesn't call a wholly independent professional witness.
Well, let me say it's like criticism. But I'll move on, but can I...
But that's just what you were saying. You were saying, in effect, they should have put Dr. Chadwick as a Christian into the lion's den and said, good morning. That's not how litigation works.
Well, I asked the Lordship to direct yourself in accordance with Harrington for the Railways Law, which is, we would suggest, as a matter of English law, accept not the ROC law, but we would accept that there's a common law jurisdiction applying common law principles. It is appropriate to draw adverse inferences from the witness who would be expected to support the party's case, if true, and whose natural sympathies and allegiance will lie with that party. The Lordship's approach does not accord with that direction. If I may, Lord, after...
The approach is that if a witness is not called by a party, the court will assume that that party did not think there was any useful evidence that witness could give.
No, it goes further, because what happened in Harrington...
Well, you show me the authority if you think I'm wrong.
Yes, will do. The last round on the notice is famous for long reasons now relied upon. In opening submissions, the famous is relied upon the rounds A, B, C, F, and H. Neither their particulars of claim nor their reply set out any factual matters which support those facts which would support a dismissal under that clause. For example, there's no statement in the plea that I could find that there was a material interference with Mr. Wells' duties. The facts relied upon by the other side clauses are not laid out either. There's no facts showing serious and demonstrable injury, and there's no allegation that Mr. Wells knowingly and intentionally breached the RELLC's orders. Now, he was cross-examined on that, and I think the learned friend did get out of the concession that he knew about the licensing laws, but it's not in the notice, it's not in the written reasons for dismissal. The only fact was in the notice that could be said to support dismissal are the matters emerging at ABC, which is material violation of material company policy. But again, if it's the lack of particularity, that I don't say that that is not satisfied under this particular subject. Well, the second reason would say that this...
if you're moving on to another topic, it might be sensible to let a short break, if that's convenient. We'll rise until 20 to 12.
All right.
in relation to the only identified ground in the written notice, we say it's not laid out because there's a failure to demonstrate interference with performance of Mr. Rella's duties. It's the employment contract. Says that 8BH, executive use of alcohol or drugs which materially interferes with the performance of his duties. What we say, the only evidence on that was what my learned friend sought to extract from the examination of Mr. Monster, and it was the sort of, the argument was, well, if you're drinking, then how can you possibly credibly uphold the company policy? Well, the problem with that is that, well, a number of problems. The first problem with that is that it can't be said that he was drinking on duty. That there's no evidence that he was drinking on duty. The evidence is drinking after hours. He interfered with the performance of RR's duties, what we suggest was to give its obvious meaning on the clause. Its obvious meaning is that you're under the influence of alcohol or drugs. That's what that clause is getting. And there is no suggestion at any stage that Mr. Rella was drunk, either on duty or after hours. Well, I think the other way it was put was to say, well, if you didn't turn up for work the next morning, and the reason for that was because you'd been staying in the bar late. The problem with that argument is that there's no evidence that it was the use of alcohol that caused Mr. Rella not to come up the next station. Maybe he was up late talking to VIPs and being his usual charm self. Well, we suggest that there's a good deal more that is needed before one can make a finding under 8BH, and there has to be a close causal link, we suggest, between the performance and the use of alcohol. And the word material there makes plain that the influence of the alcohol has to have, for example, just even being slightly New Year's Eve, for example, having a drink on terrace as he told Mr. Cadbury was going to do. That wouldn't be enough. It wouldn't be enough to say, well, I noticed after a drink on terrace New Year's Eve that you seem slightly merrier, something like that. That's the effect of your judgment. It has to be far more than that. Well, there is an absence of any serious and demonstrable injury to the company that's required by 8BB. That's fraud, embezzlement, gross negligence, self-danger, theft, asset relocation, stock mishandling, unauthorised transactions, commissions, bribes, dishonesty, or other gross and willful misconduct, which has caused serious and demonstrable injury to the company. Well, I also question whether this conduct can be fairly brought within that clause, because other gross or willful misconduct must be given its meaning in accordance with the list or class that precedes it. And this is clearly talking about dishonesty. And this is not, we suggest, an offence of dishonesty, and we suggest that is correct. I've said the absence of knowledge in relation to violation of laws. I think fairly, there is a section of the charge where Mr. Rella was asked about his understanding of the IFC laws and the ownership of the ownership of own rights, whether that's serious enough. We suggest, clear enough, I'm so sorry, we suggest that the knowledge here and the willful executive material, knowledge and intentional failure to comply with applicable laws with respect to the execution of company business operation. We suggest that implies a degree of specific intent that one's setting about quite intentionally to break the laws. If there was a breach of laws here, it was incidental. And Mr. Rella, we asked the Lordship to find genuine thought it was a fairly minor technical breach. It is important to distinguish between himself violate the liquor laws isn't a breach of the liquor laws. The breach would be if he serves customers on them too. And in cross-examination, when Mr. Rella said, well, people are given drinks at 1:59 and they're allowed to drink them up, the legal friend said, well, that's ridiculous. That's the most clear sort of driving coach and horses through the laws. But then when I cross-examined Mr. Turner, it turns out that that's still going on. That customers can order a bottle of wine at 1:59 and then drink it up afterwards. Well, my friend says it says you can drink till 3. I don't think that's how you put it to Mr. Rella. But there's nothing in the liquor laws about that. This hour's grace is entirely made up. Well, the truth of the matter is, hopefully applying a bit of common sense here, that the liquor laws, of course, are important. But as Mr. Riccio told your lordship, he can't think any instance where restaurants would close down. What was more concerning, we suggest, to Mr. Chadwick, was that some fight or some round behaviour would break out, and that would prejudice the renewal of the liquor licence. That's what he was really concerned with, and one can see that. So Lord, we say that F is not satisfied. Lord, there's then C, material violation by executive of any material company policy. Lord, I think I have to accept that has been laid out. But I certainly do not accept to a serious extent. And one has to think very carefully about what the prohibition covered, what it didn't cover, and what actually has been proved before the lordship happened. We have, at the very highest of the claimant's case, we have a very limited number of claimants in January. We have evidence that Mr. Rella was himself drinking. The lordship's been shown no direct evidence by way of CCTV or anything else of Mr. Rella himself serving another person. The suggestion is that because he was present when people were being served, he was responsible. I'm not denying that. It was a limited, very limited in scope, very limited in time. And we suggest that although 8BC is probably laid out here, it's not to a serious extent. Now, in relation to failure to act as a regional employer, we say that as a minimum, and I accept what the learned friend said notionally, that your lordship can't look at these circumstances and say, well, I wouldn't have dismissed Mr. Rella, therefore Mr. Cadry should not. I accept that we have to show that this is demonstrably unreasonable. But that doesn't mean we say that the threshold is so low that virtually any employer who gives some sort of reason can get over it. Nor we say there are some minimum guiding principles that the lordship can adopt. The first is that any reasonable employer must take account of all relevant factors and must not take account of irrelevant factors. Nor we rely upon, firstly, that that's as much the claims accepted as much in cross-examination. And indeed, Mr. Cadry used them initially when I was seeking to investigate and explore this. He said, any breach of policy, you have to look at the specific circumstances before you can understand and interpret it. There's no such thing as a generic answer. And much the same in other instances. Have to understand the circumstances. The lordship indicated the lordship agree, and we agree. You want an explanation, you want to take account of other people, and you want to ensure fair treatment across the employees. And he accepted that, page 1 and 3. I want to make sure the investigation was correctly done. Question you wouldn't want to, for example, make a special example of Mr. Rella and then just let other people off completely. That wouldn't be right, would it? Answer, I don't think any employee should be treated any better or any worse than anybody else. Now, what we stress, there can't be any business that can borrow the concept of going to be unreasonable and bring it into play here. That is a test which is now considered to be the test called irrationality. With their recital that obviously very well known passage from the case. So we say if I can show that Mr. Cadry failed to take account of relevant factors or took into account irrelevant factors, it's unreasonable. And what it is important to distinguish here between unreasonableness in the decision-making process and an unreasonable decision at the end. It's the case law that only friend relied upon. Very much of the English law employment case law concerns an investigation as to whether the employer's reaction was reasonable. So an employer presented with a set of facts, he considers all the facts and says, well, I'm going to dismiss. And the employee goes to the tribunal and says, well, hang on, I'm under record 20 years, there's this and there's that and the other, that can't be right. And the court say, well, we can see that there's room to disagree. One reason the employer might keep the employee on, give them another chance, another might dismiss. But I'm not focusing on that. I'm focusing on reasonableness in the decision-making process. And what we say is the decision-making process was very seriously flawed. And those answers that the Lordship can, we suggest, make findings upon the confidence. We also add on, paragraph 21, that a reasonable employer will never act arbitrarily or in a manner which may be described as capricious. His approach will be consistent and he will observe certain minimal standards of fairness. Not the fairness to be expected in the corporate law, but minimal standards of fairness, giving, for example, an employee a chance to explain himself, looking at what other people have done. And also the moving the goalpost point, putting the rug from one's feet. A reasonable employer does not create in an employee a reasonable expectation, legitimate expectation, that if he is rehabilitated, he can come back and then move the goalpost completely. That is not what a reasonable employer does. Neither does a reasonable employer dismiss for one set of reasons and then well, can I just, George, just give me one minute to well, we suggest, in one sense, it doesn't much matter to you, but the true position is probably that the guiding spirit and mind for the purposes of dismissal was just Mr. Cadry. That was Mr. Turber's evidence. Question, do you know who it was who made the decision to dismiss at the end? Answer, Chairman, Mr. Cadry, that he always, before they do the suspension meeting, comes to explain to me, myself, and Chef Andre. I know the word explain. He's not consulted, he is simply explaining to him. Now, in fairness, Mr. Moster, his understanding was that it was the partners that made the decision. It doesn't much matter because the flaws of the state as a legal approach, but for what it's worth, we say that the evidence suggests that Mr. Cadry's call. Now, the Lordship is going to have to make a finding as to what impression Mr. RELLA was given at the suspension meeting on the 26th of January. And we say that the true position was that Mr. RELLA was suspended for rehabilitation, or at least predominantly so. And we do not doubt that there was a need to investigate as well, but the dominant reason given and the grounds upon which Mr. Turbulence and the Rivera supported the decision was to rehabilitate. The Lordship will recall the email of 22nd of March. I put that to Mr. Cadry. Firstly, I put it to him without showing him the email at an earlier stage, and he point blank denied what he said in that email. But there's no getting away from it. It's a contemporaneous document. It must be a reliable source of evidence for the Lordship as to what was in fact said. We have Mr. Rivera's evidence, day 319. Yes, you were present at the meeting with Mr. RELLA when he was suspended on 26th of January. Answer the day, I do not remember Mr. Hamilton talking to maybe he was stuff with a problem, and then he was suspended for rehabilitation for himself. Yes, I was involved. And to be fair, this is an email in March, but I'm asking whether it's what Mr. Cadbury said in January. Words are, I repeated that the business decision at the time would have been simply to terminate him, but I wanted to give him a chance to prove to me that he was able to get better and rehabilitate himself, not because he had to, but because he wanted to. That was what Mr. Cadbury said to me in January, wasn't it? Yes, Mr. Cadbury said yes, and that was why we agreed to the suspension. I have to serve the company, take the decision as I said. Mr. Chadwick, he did say and investigate, to be fair, Mr. Rowe was suspended on 20th January, it was so rehabilitated, didn't you? After the suspension was for his own good, that's what I know. So that he could deal with any issues he had, get better, and come back to work. I don't know, so I don't know how many months, how many years it would take. That's how he understood that he was, the hope was he would get better and come back to work. And he did say, and also to complete the investigation. I'm not saying there wasn't a need to investigate. What I'm saying is the impression is the relative, the dominant purpose was rehabilitation. We suggest that the Mr. Cadbury or our CL's conduct and the decision-making process fell well below the standards we expected of the reasonable employee. And we rely on nine reasons. Firstly, failure to honour the statements made at the suspension meeting with reasonable expectations that the purpose was to rehabilitate. Secondly, moving the goalposts and taking account of Mr. Rowe's failure to be sufficiently contrite without at least putting this to him and giving him the opportunity to demonstrate sufficient contrition. Thirdly, disregarding his email and margin screws around without at least investigating whether the ground was made out. Wasn't putting Mr. Rowe in cross-examination and which he knew that unreasonable. Fourthly, failing to consider all the evidence with reasonable care, in particular the bar logbook on Mr. Cadbury's testimony. I didn't look at the logbook. Insisting that Mr. Rowe would take extensive medical tests and therapy, etc., and then apparently ignoring the fact that the medical evidence could not be better. Sixthly, failing to consider the position of other senior employees, especially Mr. Gavino and other senior partners who guilty of precisely the same offences, currently unpunished. And we know that Mr. Turner was also involved on his own offences. Seventhly, disparaging treatment with other senior employees and partners. Mr. Gavino and Mr. Turner was involved, but also Mr. Gabriani. And he wasn't at all affected. He point blank refused to accept that he could have breached the policy. And we see that from his warning letter. Eighthly, if there was a genuine concern as to the records, which is not accepted, and we suggest your lordship should treat that evidence with a great deal of caution. But if there was a genuine concern, a reasonable employer would want to bring Mr. Rowe back into the business and could arrange a joint meeting and also reassurances from Mr. Rowe about the wanted intent. And when I say joint meeting, I mean a meeting with Mr. Rowe, Mr. Gavino, and Mr. Turner, and effectively a kiss and make up meeting, and the sort of called, can you three work together or not? There was no attempt to investigate this or take any steps to see whether this was genuine. And the fact that Mr. Rowe was upset on the 26th of January is hardly surprising. Mr. Turner accepted this, and he said it's a normal human being reaction. Of course he was upset. The absenteeism issue ought never to have been raised at all. Mr. Cadbury evidence said that he counted 147 days absence. The highest record that records could support was the document that Mr. Moscow was shown in re-examination of B3542, which suggests, I think, 4 days. But this has to be read in conjunction with the email correspondence, which ended on the 17th of March, where Mr. Rowe was told about 5 days. He made inquiries, he got the material together from the company's own records to suggest that he was not guilty. And he didn't even respond. There wasn't even a response to it. We accept that the court is not to substitute its own view as to what the reasonable response would be. But one must not, we suggest, go too far in the other direction and suggest that the standard is so low that Mr. Cadbury could effectively do what he wanted so long as he had some reasons. Acting with reasons doesn't mean that the conduct is ipso facto reasonable. The standard is effectively a negligent standard. All reasonable employers approach these decisions with due care. And if the court is satisfied that the decision-making process was flawed, the dismissal was not in accordance with the actions of a reasonable employer. Well, that was then whether there was serious cause under clause 3.9, and we suggest that serious cause in that context was to be given a very narrow meaning. And we suggest that for four reasons. Firstly, the draconian consequences of the forfeiture. Secondly, the fact that clause 8 already covers matters of the utmost gravity. For example, it refers to being convicted of a crime of moral turpitude, and then adds the additional requirement of serious economic injury or serious injury to reputation. That's clause 8BA. So what we have under clause 8, there are some examples there where the matters are very serious in any event. And what clause 3.9 is saying is it's not the full breadth of circumstances that we find in clause 8B that will justify forfeiture. It's only serious causes at the very far end of the scale of gravity. Thirdly, the use of the word serious within clause 8 reinforces this point. For example, references to serious economic injury and serious demonstrable injury at clause 8B. And we'll also point out that clause 3.9 is the product of the claimant's drafting and should be construed against them. They can be expected to look after themselves. Well, we suggest that the principle of contra profferentum applies not because English law applies, but on the aid to construction rationale identified in F1 capital on page paragraph 112. And we say that the broad language of the UIC contract law, Article 61, which says that your lordship should have regard to all the circumstances in construing a written instrument, we suggest that these matters are the contra-preferential fall within that broad compass. It's submitted, my lord, that your lordship should have regard to the sanction that clause 3.9 provides in its context. And we suggest that what we're really here looking at breaches of duty that have caused a material deterioration in the value of the shares. So in other words, Mr. Chadwick is entitled to say, if you breach this contract in such a way that it adversely affects the value of my shareholding, then you lose your shares. And that would give the cause some sort of commercial justification. Nor we suggest, and there's no, I'm not going to go over it again, but insofar as any grounds are laid out under clause 8B, they are not so serious as to merit forfeiture of this shareholding. More in relation to relief from forfeiture, your lordship asked me to address you on 2 points. Firstly, how we can rely upon relief from forfeiture as a matter of the RELLA law, and secondly, what facts we would rely upon. More in terms of how we get there, we state that the relief that is available to...
Well, you haven't yet made an application to amend for that purpose. I dare say that will be dismissed as an unduly technical point. The position is that you haven't yet made an amendment, an application to amend to allow relief for forfeiture.
Well, I can make the application now. Well, I do apply for...
well, if you're making an application to amend, then I need to hear Mr. Brown on that.
Well,
whether he resisted.
I don't disagree.
Do you say you need to make an application to amend?
Well, your lordship knows that the primary position was that it's a matter that is at large, but we did put in an amendment because we thought that it was the sort of point that the claimant should have forewarned for. In English procedure, relief from forfeiture, best of my research would suggest you wouldn't need to plead it if the court was satisfied.
Well, if you don't want to plead it, that's fine. We'll go ahead on that basis. If you want to make an application, then I need to have Mr. Brown back.
Yeah. Well, I do want to make an application because what I don't want to do is find myself in peril. The lordship in the judgment said, well, Mr. Downs didn't make an application and we ought to have done because it was a matter that needed pleading. And so, therefore, I'm not going to deal with that. Well, in relation to, well, would you just speak a moment with yes, it's DIOC rules amendments to statement of purpose. And we are obviously under 1842(2). If it needs to be a possible permission of the court. And then 1812. There's guidance given to, obviously, the other side's position. The party should consent to a proposed amendment unless it has substantial grounds to objection to it. And obviously, we'll wait to hear what those grounds are. 1813, obviously, we're in the course of hearing. 1814, we're making an application stating the case the applicant should file with the court the application notice. We haven't done that. If that's something the law requires us to do, obviously we're undertaking to do that. Secondly, a copy of the statement of case of the proposed amendment, we've done that. Any evidence that this can support the application will be evidence, the only evidence unlike on this evidence available to you. Later it should be avoided and maybe disallowed, of course. What I don't think there's any further guidance. There's the commentary at 18.22. Consider the need for amending statements of case prior to the first subsequent case management conference. Part of fairness to see to amend the statement of case when such amendment is clearly necessary. Now the party may apply to strike out the whole part of the statement of case with 416 of that. I don't think is suggested. Court would generally permit amendment to do so further the overall objective, which is obviously dealing with justice, particularly with what we had to the stage of the proceedings to which the applications were made, accepted to late, the extent of nature of the amendment, and the degree to which, if at all, the amendment would cause prejudice to the other party. We suggest there is no prejudice here. The court has a wide discretion as to how to deal with the consequential cost of the amendment. Obviously, costs will come later if we got the amendment. Ordinarily, in order to pay the costs, I'd say that's the usual law. Lord, in relation to prejudice and the scope of the issues, Lord, would you also just look at paragraph 30 of the note of closing? These are the matters that we rely upon. And we say that these are matters either of law or matters which are common ground. There's nothing that we say here that could be controversial. We say that on any view, the value of the shares, whether viewed as a 30% shareholder or 17% shareholder, will be substantial. The 2013 accounts, which are the claimant's documents, show ICO net assets of dear over 6 million and profits of dear over 6.7 million. The shareholder loan of 9.7 million was repaid in the first, effectively the first full year of operation, and those who are under the cities have their profit. Now, the learned friend cannot say that these shares don't have substantial value. We may not be able to put a figure on it, I accept that, but we don't need to put a figure on it to be able to proceed on the basis that this is a substantial value of that asset, a substantial value. Secondly, there is no damage to the company because the shareholders' agreement does not regulate the position as between Mr. RELLA and the company. It regulates the position between Mr. RELLA and Mr. Chadwick. And Mr. Chadwick could not claim for any damage to the company. None having been legal approved to say. But even if, Learned Friend says, well, if I know I put forward a case on substantial damage, it wouldn't help him because the company would own that claim. And Mr. Chadwick would not be able to put himself, he would not be able to escape the rules in relation to claims for effective loss. So, under the shareholders' agreement, as between Mr. RELLA and Mr. Chadwick, which are the only two protagonists, Mr. Chadwick has no loss that he can claim, and Mr. RELLA is as a result of the alleged breaches of the rules and concepts of state value. And we also say that the clause is highly unsatisfactory in any event, because on its face it provides that Mr. RELLA will forfeit his shares if Mr. Rivera and Mr. Turbo dismiss the serious cause. That requires, the court should be concerned about that, and it also on its face, as your lordship pointed out, provides that Mr. Rella's, Mr. Rivera and Mr. Turbo's shares are lost because of the breach by Mr. Rella. And we do suggest that the natural reading of the court means that it's unlimited in time and space and carries with it no commercial advantage. Now, those are the factors that I write on. They're exactly the factors we provided on relation to penalty clause. So the ambit of factual dispute in this case hasn't really changed. All that's happened is we are not saying, can we please put forward the argument of those same facts entitled us for entitled the court, I should say, to consider the forfeiture. And your lordship obviously doesn't need to be the language, but the doctrine of agreement and forfeiture and the penalty clause doctrine are very closely aligned in their sources of background and the sort of factors that are to be considered. And we've cited just above that some of the the factors are well established and suspect of recognition. Well, that's my application to review.
Well, 1812 indicates that questions of amendment should, if possible, be dealt with by consent. Has Mr. Brown's consent been sought, and if so, is it given or not?
It was sought in the sense that I asked him when we gave him the amendments, was it going to be controversial? He said he was going to think about it. I haven't followed that up. I said to him, oh, by the way, what's your position?
Well, I'd better ask Mr. Brown if he consents to this amendment.
My lord, I don't.
This is a document headed draft re-amended defence and counterclaim. It contains, among other various amendments, an amendment to insert subparagraph little 3 in paragraph 20. You oppose that?
My lord, I do oppose this, yes.
Well, you better tell me why. It also has certain other amendments in it, including one at little 4b on page 10.
Yes, little 4b we previously consented to because we accept that that's a matter that flows from the contract and that there's very little way evidence.
So you don't object to little 4b
My lord, no.
on page 10? No. On the basis that you don't object to little 4b, I will give leave to amend to include little 4b in paragraph 43 of the amended document.
My lord, to an extent that needs backdating because it was downgraded on day one. And on day one I said I didn't object to that amendment.
Well then, what about little 3 of paragraph 20?
My lord, we do object to that. We accept that the underlying factual matters asserted in terms of the conduct of the second claimant is something that's been in play all along. But we say that the disparity point is a new one, and it's not been in play because, of course, what you said about the relief from forfeiture application is that it should be made, and that if there were any new facts that needed to be found, that would be a matter that was under consideration of this application. And we say that the disparity between
you object to the introduction of little 3 in paragraph 20 if sub little 4 in that paragraph is taken out?
Well, no, the other matters are clearly before the court.
Is there anything you wish to say, Mr. Downs?
We suggest that damage has always been a crucial part of this case. The employment contract in relation to certain of the headings requires that the employer demonstrate serious and demonstrable injury to the company. That's 8B. And that was no different than the very fourth one was over this issue. So the suggestion that they took no consideration to the need to come here to prove injury to the company, we suggest is implausible. In any event, the way that I put it in the opening note is that we say that as a matter of law, there is no damage here, because one's concerned with damage to Mr. Chadwick, not damage to the company. Damage to the company is unaffected by this clause because the company will always have its claim. Mr. Chadwick could not pursue that because of Johnson or the rules on the contract he lost. Nor in relation to little 4. Well, just to be clear, all that I would seek to do is set up the value of the company by reference to the claimant's own audited accounts. Can I just show you where they are on numbers? It's in bundle C. And tab 34. Mr. Chadwick told the lordship that this is not an audited version, it's a draft version. But Mr. Chadwick told the lordship that this is now audited. And on a company of 16 million dirhams net assets, and which is generating a profit of 6 million dirhams, one doesn't need to carry out an evaluation to know that that company has substantial value. This is the claimant's own document. They can't shrink from it. And that's all I need. So more on that basis, there can be no prejudice.
I'm not afraid there's
I don't need to trouble you, Mr. Brown. If this application for leave to amend is made at a very late stage, after the court having been told that no lumps has been placed upon relief from forfeiture, I will allow the amendment in relation to subparagraphs little 1, little 2 and little 3 in subparagraph 20, little 3 of the proposed document. I will not allow the amendment in relation to little 4. There has been no evidence as to the value of the property as at the time of the alleged forfeiture. If that point was going to be run, it was necessary that it should be treated as supported by evidence. And it wasn't. And it wasn't for the deliberate reason that was not part of the defendant's case. It's too late to bring it on their plaintiff at this stage.
And so I think I've dealt with the I think I still need to deal with the law on relief from forfeiture. And that we say that your lordship cannot apply the principles, not because English law directly applies, but because the lordship can use those cases and those principles as aids to construction. Can I just show you the IOC on what damages and it should be in bundle 2 of my the authorities bundle. It's Article 35, divided 14.
14, I think it is.
It's divided 14. Just as you have the DIC damages and remedies.
Well, divided 14 in bundle 2 is law on the application of civil and commercial laws and the IFC.
No, it was I think I misled my friend. We've got different bundles to everyone else. I think you'll find it's 17. Tab 17, sorry.
Tab 17 of what? Of this
Of this
bundle?
same bundle.
That's the law of damages and remedies, damage, DIC law 7 of 2005. I have that.
Well, can I take your lordship to Article 34, firstly? Where this law provides that a person may claim or otherwise has a right or is entitled to compensation, damage, restitution, specific performance or any other relief or remedy, the court may, on application, make all support for it. And we just place emphasis on the word may, which we say means that there is a discretion, may or must. 35(1), where a person commits a breach of the requirement duty or obligation which is imposed under the IFC law, the court may, again not must, one of the following. And then again, when we look at specific performance, at Article 39, the court may rule on parts of the contract as long as the contractual obligation is so long as, and then it goes on. So if I'm right in suggesting that there is a discretionary element under the IFC law, the question then arises as to what principles should the court apply for the exercise of that discretion. And we suggest that your lordship can borrow from the common law the principle of equitable relief and forfeiture, which can be traced back before the first statute enacted such relief, which best I can do last night was track back to 1730 in the Anglo Pretender Act. And there's a case, Denby Evans, which was a good history. The relief that was then available to prevent unconscionable deprivation of the sentence like robbing by RELLA. We suggest that the lordship can follow those principles and apply them in this jurisdiction. And well, if one thinks of the contrary proposition would be more surprising. The contrary proposition is, well, the DIFC laws in the exercise of their discretion, the legislature intended that factors such as the conduct of the applicant, the gravity of the breach, disparity of the value of the property damage caused by the breach, should not be relevant considerations to the availability of such discretionary relief. It would be very difficult to support an argument that those factors should not be considered as part of the discretion. So that's how I get to it. George, just bear in mind that that's something on the previous.
Do I have in the bundle the authority referred to Spans Equity?
No, it's on its way. The authorities are being printed, your lordship, as we speak. I can actually, if your lordship, I have a copy. It's actually a court's copy of the executive. It's a very brief
Yes, is there anything else you want to say?
The only thing I would say is that it is open to people. I do rely upon reading in relation to penalty clauses, which is at paragraph 20, sub 2 of the offence, where it's pleaded that clause 3.9 is unenforceable. The clause is penal in nature, requires that the offence false shareholder holds be forfeited on some measures of violence and unconscionable. Its predominant function is deterrence against legal or personal animal resignations, inclusion of any commercial justification. Well, I can rely on those assertions, and I say that the material which it does have in the bottom, including the accounts for 2012 and for 2013, are permissible. I also say that your Lordship in a relief and forfeiture case does not have to look at the position as at the date of the dismissal. Your Lordship can also look for the position as at today's date, because it is an actual discretion remembered. And if there are events and circumstances that are not known or known then, are known or known then, your Lordship should not shut. Which applies to those events. If it's unconscionable now to rely on the relief for a specific performance, even though the facts and matters which demonstrate that unconscionability were not known at the time, they are still matters we say which affects the approach of the court. And so, notwithstanding the Lordship's refusal to allow us to amend, I do rely on facts and matters at paragraph 30. They are before the court, and they are sufficient. My learned friend says that he has journeyed to England and challenged his own audit of accounts, or to, for some reason, to assert that Johnson got wood top of the law here, as it were, in the UK, obviously you can do so. But I say that those are still in play. Alternatively, as you also knows, we say that it's a penalty. It was the other way where Mr. Relic into Royal and construing the clause in a more narrow context at the time. I do accept that the penalty issue does have to construe the clause at the time. In that situation, we said that he's still in nature. It means that Mr. Chadwick indirectly becomes 100% shareholder of the company for a breach of any of the three, effectively, because if Mr. RELLA is in breach, the shareholding is forfeited. If Mr. ROBERTO'S is in breach, the shareholding is forfeited. And Mr. PAOLO is in breach, the entire shareholding is forfeited. And we say that cannot be anything other than the clearest penalty clause imaginable. More on unfair prejudice, I'm not going to say anything more than we said in the opening. We say that, and I think it's common ground that there is prejudice. Although the French point is well, we satisfy dismissal, terms of dismissal and prejudice are contrary fair. So, of course, principally, if I can satisfy your Lordship that our dismissal was not within the terms of Clause 3.9, then the prejudice is established in attempts to, or the successful attempts to reject us from business. Well, there is a residual point here that I would ask your Lordship just to have in mind and make sure it doesn't fall through the gaps. Even in a case where Clause 3.9 applies, and even in a case where there is, your Lordship finds, well, it's satisfied and there's no reason not to enforce it, there is still a residual discretion that your Lordship would have to find that because this was a quasi-partnership, your Lordship can look at the full picture. Now, I do accept that the authorities say that what is fair or unfair, one first looks at the contracts, the articles, shareholders' agreement and the like. And if one brings oneself within those, prima facie, it's fair. But the court can say, notwithstanding that you are within these terms, in this case, it's unfair. And we would say that would apply in this case because of the nature of the relationship, the nature of the team, the fact that all three of the other partners were in breach of this policy. The fact that Mr. Rella he's going to be singled out. He's the one who's going to lose his shares. Mr. Chadwick says he'll give the other partners their shares by some other route.
Well, I don't think that's the effect of the clause. I think that the clause applies to the 600 shares that are registered in Mr. Chadwick and Mr. Rella's name. I don't think you can interpret the clause as to apply to some other shares.
No, I agree with you, Lordship.
So I think it's all or nothing. And if Mr. Chadwick persuades me that the 600 shares should be forfeited, then of course it's open to Mr. Chadwick, if he wishes to do so, to allot percentages to the other two partners. But I don't at the moment see how 3.9 can be construed to cover shares which are not registered in the name of an individual.
Well, I agree, that's exactly what
I think it's. I think if 3.9 applies, it applies to Mr. Rella's 600 shares.
Well, I obviously expressed that very badly because that's what I was trying to say. Can I just show you Lordship 3.9 and hopefully make a little bit more lucidly make the point? It's in the core bundle and it's a tab.
Well, just before you do that, the position as to what the shareholding is in this company is far from clear. It's certainly not clear from the articles of the shareholders agreement that the document that I was given, which was the online return, does seem to show who is currently registered as the holder of shares, or at least it would do if it wasn't that the document itself is inaccurate. Or potentially not, well, inaccurate may be the wrong word, but that it shows Mr. Chadwick as being the owner of 1,400 shares and also the owner of 600 shares. But when you look at the details given for Mr. Chadwick, it's not Mr. Chadwick, it's Mr. Rella. So I'm not at all clear what the parties say the true position is.
Your Lordship, right about all that. I'll tell your Lordship what I say the true position is. Your Lordship ought to know that overnight we did a check on the registry to see what the not the share registry, but the company registry, so what details were recorded in relation to the company. Can I just hand up to your Lordship?
Yeah.
What that says?
What I would have expected, but this is clearly based on English practice, is that the company would keep a register of members, but that doesn't seem to be the case.
I think, my Lord, that the way things operate here is that the register is not maintained by the company, it's maintained by the equivalent of Company's House. And a bit like land registry in the UK, that's what provides the record. But we looked at, I mean, it's entirely innocent, but I did think your Lordship, I knew your Lordship was interested in it, and I thought your Lordship ought to be shown this. Well, in fairness, only because it's come up. It does record only one shareholder, and it records that shareholder's holding as 2,000 shares. Now, to be fair, it could be that this is somebody simply looked at the company registry that we saw the day before yesterday and wrongly interpreted that document. Well, what we would say the position is that there are two shareholders, but we are still a shareholder in 600. That's clear when one looks at the register, even though it's got the wrong name on it. And that could be dealt with by rectification if necessary. But more, the state for the fact this is a bit odd, as your Lordship's remarked, and unless it's going to be said against me, I don't have lockers, because I'm not a a legal shareholder, which I don't think you said. It's probably just something that can be sorted out later. But you sure want to make Mr. Brown on this? Or shall I do wrong?
Well, the point is only material if it is accepted that your client is the registered owner of 600 shares. But since that's actually the relief that the claimant seeks, it probably has to be accepted that you are.
Yes.
My Lord, we accept it. We've got no explanation for this document. It's not something we've had a hand in. As Mr. Dunn said, you saw yesterday's document. You said 3 out of 10 on a good day, and that wasn't our efforts. It was the registry's records that they had Mr. Rella down with his passport, date of birth, and his details, but put Mr. Humphrey's name in. We accept that Mr. Rella is the owner of 600 shares.
Is the registered owner. Well, I mean, you have to accept that in order to provide a foundation for the relief you seek, because if he's not the owner of registered owner of 600 shares, then there's no point in making that award.
No, and of course, as Mr. Down said, I would take the point that he had no office to go for unfair prejudice claim, because he simply wouldn't be a shareholder. So it cuts both ways, but I think we're on the same page on that.
Well, I think Mr. Downs, we have to proceed on the basis that whatever the online registry shows, Mr. Rella is the registered owner of 600 shares. And it's those 600 shares which are the subject of the claim for that they be rendered, I think, whatever that means.
Well, can I make the point that I was seeking to make on 3.9 more hopefully more understandable? Could you also look at 3.9? It's in the shareholders agreement, which is attached 6 of the court document. And it's at page 228. And the point I was seeking to make is that the forfeiture of Mr. Rella's shares, the 600 shares, is triggered by a breach, a serious breach or serious cause of any of the second, third, or fourth. So if just one of them is in serious breach, sufficiently serious breach of their duties, all those shares go. That is, we suggest, obviously your lordship has the point that that means that if Mr. Rella is in breach, all of the shares go and Mr. Vera is total part trial. But it also cuts the other way. It means that if Mr. Vera is in serious breach, Mr. Rella will lose all of his shares. And that is a very, very surprising result. And what effectively we have here is the two sides of the agreement, Mr. Cadry on the one and the team on the other. And what Mr. Cadry has secured, and the benefit of the covenant, which provides that the shares are held by the weakest link. One of the breaches, that's it, the result. So we say that's the natural meaning of the clause, and unlimited in time. We say that is sufficient to bring into favour of community law. More unfair prejudice, I was going to say nothing more about that, other than to just ask your lordship not to forget that even if we lose on everything to this point, accept if that does happen, doesn't look too favourable to Smith, but if your lordship must then also consider whether, notwithstanding those matters, there is still residual unfairness. And those are the sort of factors that your lordship could take account of. incredibly harsh alternatives of cause. Your Lordship can take account of the circumstances of the dismissal. Your Lordship can take account of the whole picture. And we say that the result would be unfair, even if we can't get around the clause, even if we were move forward in it, it's still, there's something wrong here about that result that we suggest. For in relation to other employment issues, very, very briefly.
Well, can I just take that in stages? If your client was dismissed as an employee, do you say that dismissing him as an employee would constitute unfairness under Section 134?
Well, partly it's the exclusion from management. So it's the exclusion from management. So it's the consequences.
Well, exclusion from management, his right to be involved in management, as I see it at the moment, stems from his position as a partner.
Yes.
That's what the articles provide.
Yes.
Dismissing him from employment doesn't, as it seems to me, the method equate to dismissing him as a partner in the sense that partner is used in this company, which I think is to mean effectively amendment for the board.
Your Lordship's right. We would say that he could be dismissed from employment but still allowed to be a partner without direct executive responsibilities.
Well, leading on from there, my present view, subject to what Mr. Brown may want to say to me, is that your client hasn't yet been removed as a partner under the articles. If you look at the articles, provide the word manager, 17 a manager. Manager's office is automatically vacated. This is page 44 in the court article. I have yet to be persuaded that any of those things have actually happened. But it would be naive not to recognise that if your client's shares were forfeited, if it would be fairly promptly removed by resolution of whoever the members then were. Well, now, if that happened, and he were removed by resolution of the members, in circumstances where the court had decided that he was no longer a member because of the operation 3-9, are you going to seek to persuade me that that would be unfair conduct? And if 3-9 were, 3-9 has the effect that he ceases to be a member, and I'm not persuaded to relieve him from the consequences of 3-9 if it's important, then even if he's not also removed as a manager at the same time, it would be fairly obvious that he would be likely to be very soon afterwards.
Yes. Well, I will answer that more. Can I just tell you, which probably hasn't come across it because it's buried in one of the bundles that nobody really looks at the later bundle, but there's a notice in bundle B4 at page 660 of a ordinance.
Sorry, D4.
B4.
D4. Page.
And it's page 660.
April. This is very recent.
It is.
Yeah, no, I haven't seen this before.
No, it's noticed at both the board meeting and an AGM.
Excuse me. I've heard no evidence about this at all, I think.
No, well, it's subject to your lordship's order. So if your lordship looks at paragraph 3, what's intended is subject to what your lordship directs. It's not a threat to breach your lordship's order, but it is evidence that if we were to lose this case, in any respect that would permit it, Mr. Rella will immediately be removed as a...
Yes, well, thank you. I mean, that if I may say so, confirms what I would certainly have expected, obviously, to happen. Well, then if he were removed as a manager, in circumstances where the court had decided that he had ceased to be a member, then would that be unfair conduct? He ceased to be a member, so he had no longer any economic interest in the company. The company decided to remove him as a manager. Do you say that would be unfair conduct?
I would. I need to slightly need to make an adjustment to the way your lordship put it. The way I would put it is that the forfeiture of the shares as a means or the intimate step to remove as a manager means that one has to look at the two together and ask, is the forfeiture of the shares and the removal as a manager unfair to the commission? And we say that in a quasi-partnership, there is a legitimate expectation created both to the equity stake of the company and the management, and it's unrealistic to divide the two. That's the nature of partnership. And what your lordship can do is say, well, even though I find that it's in this clause, and even though clause 3.9 can be relied upon, and I wouldn't give equitable relief for forfeiture, even though I'm still going to find that in this case it's unfair. Now, I do accept that the burden is quite heavily upon me to satisfy what should be done. And I do accept that the starting point of this is in the constitution documents that go to the shareholders. That's what the case is saying. But the lordship does have a residual discretion to say, I'm going to do justice in this case. And at that point, the plumb line for what is just is it an unfair interference without expectations that were created by partnership, relationship, and third degree housing. So I would look at the way that things came about in 2010, and one would say, well, what was Mr. Weber's legitimate expectations then? Could he expect to get away with a few days drinking, whatever it is, and breaching policy, and retain his shares? And we would say most definitely. This was all the language he says in his statement. I don't think it's challenged by partners for life, brothers, all of this. We'd say yes, it would be a disappointment of his expectations, and it's a matter upon which your lordship should be prepared to interfere, even though, as I say, yes, one has name on door, all his lines come across. And one also must have in mind in this case that the kick-start that Mr. Chadwick got from this business, from Mr. Rella's involvement, was going to be more, his contribution would be more effective in the early months, bringing his clients across, giving the reputation, giving the restaurant some profile on the local scene. Once you've got those people through the door the first time, it's going to be much easier to keep them. The challenge is, can you get them through the door in the first instance? And that's why he had to be involved. And we say it would be unfair in this case to deprive him of his share of it for the facts and matters that the Lordship showed. Well, if your Lordship's happy for I move on and deal with the minor points about medical expenses and the like, we simply say here that this is a very odd sort of loan that is said to be granted. There's no paper trail on it. There are no terms upon which it's to be paid. Mr. Rella,
Do you want to deal with that at this stage? I mean, it's the claimant's claim to be repaid the medical expenses. You're entitled, I think, to say that you'll deal with it in answer to their case. But if you find it more convenient to deal with it now, that's fine.
no, I think I'll deal with it in response. Well, I haven't dealt with a mistake in the note. It's not because you dropped it. I then put it at the forefront. I simply just didn't have time. The Lordship was indicated last night, day before, the matters you wanted us to focus on. But your Lordship has in mind the principles, and we say there was a sufficient disparity of, a sufficient disparity of bargaining position that would entitle your Lordship to say that our consent was vitiated by the fact that no legal principles are implausible. And that is not implausible given that everybody also agrees to clause 3.7, which goes even further. Mr. Rella did have the rights, I accept that. But that's not, we say, a complete answer. There are gradations of inequality involved in these situations. At one end of the spectrum is somebody who is completely unsophisticated and no support, and just trusts entirely, for example, family member like just signs the document. At the other end of the extreme is somebody that's completely boarded up and has lawyers on the case negotiating. Mr. Rella was somewhere in the middle. He hadn't got his guard completely down, I accept that. But neither had got his guard completely up. And he didn't have those lawyers protecting him at the vital stages, which were the capital fundamental, and at the point at which the agreement actually was signed. He had assistance, he had help, but he was not sophisticated or not equally sophisticated as Mr. Chadwick.
Well, I've been given a document headed Chronology of Legal Advice Obtained by the Defendant, which I assume is a document which comes from the claimant's rather than from your side. You may want to deal with this at some stage, but you may want to do it after you've heard Mr. Brown further. Looking superficially at this document, and of course having in mind the submissions made in the opening written submissions or skeleton arguments, it's going to be said against your client, I think, that he did actually have plenty of opportunities to take legal advice on the shareholders' agreement. And if I were being asked to take a view as to how far the shareholders' agreement bound Mr. Booker down, I might be in a different area. I would take some persuading that Mr. Booker never had any idea of what the shareholders' agreement said. But your client, on the basis of the material outlined here, did, it said, have legal advice. You said that is a point that you're probably going to need to deal with.
Well, I accept that. I don't put the state at the forefront, but I do say that there are gradations of support by that legal advice. It's not a complete answer to a claim like this. I will accept that I have struggled, but I've just reminded you of clause 3.7. Though Lordship, it's not part of my case, I know it's not part of my case, but objectively, on the day that group was signed, any lawyer that is a pretty...
Yes, but Mr. Downs, it is quite an uphill struggle, or it's going to be quite an uphill struggle to persuade a court that if somebody had legal advice in relation to a document and still signed it, he's not bounded by it because the legal advice wasn't very good legal advice. If that were the rule, a lot of litigation would take a different turn.
Well, that I cannot say, I do not say. Can I just put it in the most attractive way I can? The doctrine of mistake operates on unilateral mistake, operates on the conscience of the beneficiary of the covenant. So the court is concerned to know, is Mr. Cadbury's conscience affected by the facts and matters that he is aware of? Now, I completely accept that in a lot of situations, person walking away from an agreement may be quite right in time to say, well, whether they saw the point or not, they had lawyers on board in trying to work and look. But I do suggest there are extreme situations of which this is one, where the nature of the clauses are so one-sided, so stacked up against the other side, that the only conclusion that could be got to is the lawyers are responsible. And they have responsibility and they have appreciated it. And if I can bring myself in that extreme situation, I say that yes, it does operate on conscience, and the court can say that. The court says fine. Well, I think I do need to deal with the trademark and the name issue at this stage, subject to your issue.
Well, do you want to do that now, or do you want to do that at 2 o'clock?
You can do that.
Very well. Well, then we'll sit again at 2 o'clock. We do need to finish this case today. So perhaps you and Mr. Brown will just discuss how much time between you think you need for that purpose.
I will say no more than 10 minutes. I have a reasonable right to it, but I can make my decision.
Thank you. This is 2 o'clock.